we decide to stand and to move around because at least we make it more entertaining, and we both try to be as entertaining as possible, and sitting down makes it difficult. And this is supposed to be an interactive session, right?
Oh, yeah. We encourage all of you to stand up, ask us questions anytime you want, interrupt us at any one time you want. We are here for you.
So who wants to begin? It's like ask us anything. And of course, probably we don't know the answer, but we're going to do the best. And the idea is to try to find out what is the best way, what are the IP considerations, the best way to pitch your game to a publisher, and the financial consideration connected to pitching these video games. Because we mentioned already in the last 4 hours that especially when it comes to register rights, they do have a different flavor, they do have a different power. It's something you can prove. That's why Daria was suggesting registration of copyright in the US. Not because we need registration for subsistence of copyright, but it's nice to have a piece of paper that shows everyone that you have copyright and you are the copyright owner. And registration in the US, I mean, it is $50, 55, they're increasing. 200 now?
200 now, yeah.
For screenshot?
For the entire work.
Ah, okay.
No, there are different levels of price. There's different price tag for different types of work. Usually the video game is under $200. Still very affordable, very recommended.
And it's pretty straightforward because you can do it online.
You can do it by accessing the Library of Congress through any website, any website browser that you have. You don't have any special account or credentials. You just go there, you upload the work. It's very straightforward. You don't need an assistance of lawyer, to be honest.
So the way the session is going to work, our dream was you pitching us an idea for a video game and we pretend to be the publisher. But I do realize that we need to break the ice a little bit before we can do that. And so we were thinking, if no one wants to volunteer, to start to answer the question we got asked during the coffee break. Because in the coffee breaks, we got a lot of questions on a lot of brilliant idea, very bad ideas. Thing that I was really happy not to be asked officially about.
Not all of the questions we will be able to answer right now, but if not, we will answer them over the coffee break afterwards.
So do we have any question from the floor? Go for it.
Any other mic? Thank you. All right. So I really apologize for tuning in for the third time for the day. I actually have 16 questions written down. Some of them have been
we have an hour, so don't worry.
I'll try to make it as brief as possible because it's in mutual interest. So I'm mostly interested in two things. The appearance of certain IPs in two categories: in content by content creators. So we're talking about someone's game or content from the game appearing in the YouTube videos and Twitch streams. And the second thing is user-generated content, or explicitly, more specifically, actually, modding and mods, the game mods. So let's say that the first question may be, so this is a very specific thing. Would it be okay to explicitly claim that all user-generated content creators waive their rights in the end-user license agreement of a certain game?
Would it be okay?
Would it be okay? All right, so I'm not a legal expert in any freaking way. So I'm very much interested in, is that legal? Is that okay? If there are exceptions, if there's some better practice on how to handle this, et cetera, et cetera.
Instead of answering depends, should I say,
Michał?
should I give you my answer and you say exactly the opposite? So we balance it out. No, first of all, user-generated content. I don't know if you noticed this morning, I totally avoid the topic. I just had a slide with UGC. I didn't want to touch it. There were good reasons. probably was going to come up anyway during the afternoon. Now, it is basically, what is the issue? The issue is that society evolved. And I'm not only talking about the internet, about video games. I mean, the earliest form of user-generated content, and this is going to show what kind of a geek I am, were fan-based Star Trek episode on VHS. This was the first time that I actually experienced this content created by users. So it's not a new thing. It's just because of computer technologies and the internet, now it's really easy to do that. When it comes to video games, there is an added layer. It's kind of cool and creates engagement of the user. People playing video games, they tend to be, and I'm generalizing, creative. The video game is interactive, is immersive, you participate. You want to play around with it. And the new generation, they do have the technical skill to do it. So it's something that you want to do it, you know how to do it, you have a platform to share it. So it's happening. User-generated content is happening. Is it potentially a copyright infringement? Yes. Unauthorized use of third-party copyrights in absence of limitations and exceptions, notice how long the sentence it is to be accurate, is a copyright infringement. The question then becomes, how do you regulate it? Because I mean, how do you deal with this massive copyright infringement? Technically, we can use notice to take down, you can use a cease and desist letter. Is it worth it? In some industries, it is worth it because enforcement is very, I'm not mentioning any industry, I'm not pointing any finger, but some industry, they really don't like people playing around with their content. I'm not mentioning the industry, but for instance, remixing is something that is not generally welcome, or use of particular contents in other form of media is not particularly welcome by some industry. In the video game industry, of course, with exception, because there are publishers or developers that they don't really like their content being reused, is something generally welcome because it increases the consumer base, and because of the reason now people enjoy video games, not only playing them, but also watching other people playing them, professionally or not, even just play through on YouTube or constantly on Twitter. There is no economic harm in the use of that IP. I personally believe that would be almost suicidal to try to stop your customers, your fans of using your IP when the use of your IP actually increments your player base. I mean, why would you do that, even if in theory you didn't otherwise? However, this gray area creates complexity because then in the area of content creators, they didn't clear the right. At least they don't know, they risk, for instance, their channel to be suspended, their video be taken down, their livelihood, because this is their main jobs. It's not an hobby anymore, content creation for a lot of streamers. And I don't like to call them influencer, but I mean, that's the general term. I don't know what they're influencing, but I don't want to get there. It's a very complex area. And we have an example in history. I don't know how many of you remember Machinima production or Machinima production. Brilliant. It was amazing. Entire 3 hours movie. It could have been like the future of filmmaking because 3D engines of video games are fantastic to recreate scenes. You put the voice actor, you have an amazing film at 1/10 of the cost. And that was really welcomed by the video game industry. But the moment the first attempt were done to actually distribute them commercially, the entire system collapsed to some extent because no one could say, yes, video game company X authorized me to use all this material to create my movie. So even if you were getting someone from a television coming to you and say, can I use your Machinima on TV? No, you cannot do that. You don't have the paperwork in place. And they were broad license. Now there is a tendency, because video game company, they understood there is a necessity to guarantee something, to include, they evolve from just IP licenses in the EULAs, but there is wording that include what the content creators can do. That, however, never reached the level of a full license of using the content for commercial uses. There are exceptions, but those are exceptions, and they're not industry-wide. I mean, some companies are extremely keen on what part you're using. For instance, secret missions or particular aspect of the video game and the timing. You don't want the entire video game being out on a Let's Play video 2 days after the launch. And those are legitimate concern. So that's why you read on the news from time to time, company X took down 5,000 videos or all the videos of one streamer on copyright claim. Because the copyright claim probably is the most straightforward to do that, even though it's not the main reason copyright, just you share the ending of the video game 3 hours after the launch. We would have not complained if it was in 2 months. And copyright is there also to protect that from the copyright owners, is maintain their control. Now, the second part of your question, and then I'll let Mike add on. Often in the past, video game company probably made the mistake to include licensing words in their end user license agreement. They create an imbalance of rights in the creation of user-generated content. There were some of them, basically, I'll simplify it for comic purpose. All licenses 10 years ago tends to include wording such as, yes, you can create content based on our IP, but you cannot use it commercially, and you cannot even put it on a website that gives you money through advertisement. However, if I like what you create, you assign the copyright to me, or you grant me an exclusive license perpetually with no economic relief of any sort. It's a bit of harsh language, and you know, an end user license agreement being split per license, we're always there. They're not negotiated. Consumer protection, if you exaggerate, will kick in. It's not if it will kick in. It will if there are unfair terms. And this harsh terminology, again, I do the theory. Michael is going to tell you the truth.
You excellently explained the side of the creator of the user-generated content, being the gamer. But there's also the other side of the fence. And once the generated content is being created, me as a developer or publisher, I might be interested in using that user-generated content for my own benefit. And that steps in the ULAs, the terms and conditions, and the entire spectrum of consumer protection laws. And this is very tricky, because you mentioned in your question that whether it is possible for a developer or publisher to force the user to waive its right under EULA. And the short answer is no. The short answer is no. The broader answer is it depends. And I hate that kind of answer, but I will explain why. Because in order for any publisher or developer to become the owner of the user-generated content, there needs to be an agreement for transfer of IP ownership. The problem with games is that agreement needs to be in writing. And since the communication between publishers, developers, and users, it's usually electronically only these days, they cannot provide for these contracts to be handwritten, ink signed, or anything else. No one will ask the user to provide electronic signature or send scanned copy of the signed contract. It doesn't work like that. So what they do, they introduce the clauses that were introduced by Gaetano into EULAs, or terms and conditions, or both. But the problem is that under EULAs and terms and conditions, you cannot effectively transfer the IP to work. You can only grant yourself a license. So what they do, they provide themselves a license, exclusive, perpetual, royalty-free, free of charge, etc., non-revocable, etc., etc. But this is in most cases allowed. This is what is being done by the biggest of this world in the industry. The problem happens when, at the same time, developers and publishers want to impose on the users any kind of waivers or limitations of liability on themselves. Here is when the consumer protection laws kicks in. And regardless of the choice of law that is being used for the terms and conditions or the EULA itself, the consumer protection laws are very jurisdictional oriented and they're self-imposing towards the provider of services. So for instance, in Europe, if there is a clause in Poland that is being forbidden under consumer protection laws, it doesn't matter if I accepted the EULA coming from the US. It will not be applicable to me. Of course, that's theory. In practice, developer frameworks may not know about this particular laws that works in Poland, but still, if they would ever decide to challenge me in court or in front of any authority, claiming that I have waived my rights, let's say to my moral rights into the works that I have created, it will not work. I will win in the court. So, coming from this perspective, you will very rarely, if ever, see that kind of waivers in EULAs or terms and conditions. If you have some spare time over the weekend, you can go through any of them. I highly doubt it that you will find that kind of limitations because it has already been tried by developers and it doesn't work. I hope that answers your question at least a bit.
And also consider there is a massive PR issue there. I mean, if your community, even if it's, I do believe it would not be enforceable, but beyond what I think, beyond going to court, the risk of a backlash of trying to claim or trying to enforce the claim or even just to share particular harsh wording in the EULAs will be picked up. I mean, I think, I don't remember who actually put that sentence on the slides before. Video games are a very attentive and active community. So it's true, sometimes they base their opinion on something they Google or on Wikipedia, but when it comes to someone is going to speak up and someone is going to point out, and there is a lot of check and comparison between a user license agreement from different games. And recently, for instance, even on Twitter, there were lengthy discussion on IP clauses not being immediately visible in the end user agreement because it was a link to another document. And if a gamer can spot it, it's not a good thing to have this. If it's not clear to your community that what you're doing is a good reason, you're just you're putting yourself in a bad position just for some harsh wording. I mean, it is an art to write.
Although there are some big, one of the biggest brands in this industry that they tend to be so IP protective about themselves that they don't care about the PR backlash that may happen to them. I will not name the name of this company, but let's just being said that it's one of the biggest company in the world, being in the market from 80s. And there is this story that has, I would probably have never heard about this story if not for the article that has been published somewhere in the US a couple of years ago about a girl that has this some sort of trauma disorder because she experienced some kind of very traumatic experience when she was a child, and she had this very she was struggling with leaving house and speaking with people that she didn't know. So what she started to do, she started to play one of the video games created by this developer, and it helped her. But she also overcame her struggles and started creating gameplays. After she started creating gameplays, she also added let's play with her narrative. And she started communicating with the world just by playing game on her console and just speaking to the broader audience that she have never met in her life. She didn't earn any money out of it. She was just getting better because of playing this game. And what this company did, they contacted her through the lawyers, demanding her to stop doing this, and also threatening with the huge lawsuit. So there are companies that they don't care about backlash. There are very few of them, I mean, among the biggest. On the other side of the fence, there are companies that we know for great RPG games with open world coming from UK, that they encourage users to create their own user-generated contents within the games. I'm speaking about the post-apocalyptic world in this game. You know what I'm talking about. They encourage you to use the tools that they implemented in the game for your joy, so that you can play and enjoy the game years after the release, even without further release, further DLCs from the developer. Same goes for, I think you mentioned also modding at some point. You mentioned modding, right? This is exactly the same approach. It does not fall within the definition of user-generated content because it's within the game itself, using the tools within the game. But modding is yet another example of how developers and publishers approach users. There is a group of publishers, developers that they encourage you to mod their games. On the other side of the fence, there are developers that they will forbid expressively, explicitly, in capitalized terms, that you are not allowed to mod our games. And any situation, any scenario, when you try doing so, you will be prosecuted. We will come for you. So there is no universal approach, even though that speaking about like coming from the gamer perspective, not lawyer perspective, for me that would be only logical to allow people create their own mods. Of course, as long as they do not ultimately benefit out of it or do something which is illegal or strongly disadvised, like pornographic, like supporting totalitarian regimes, etc., etc. But as long as it make the game more livid, more vivid, and prolong the life of the game itself, it would be only logical to allow for it. But still, not everybody does it, and this is how the companies works, basically.
Well, yes, the thing is, there are horror stories about, enforcement against your player, terrible thing on the license. I remember one of my favorite game. There was a termination clause. They could terminate my account at any time, but in order for me to terminate the contract, I had to destroy the code. I have to send a recorded letter. I have to destroy it. This is all the video game from my computer and destroy the physical copy in order to, but these are just wording. No court would ever enforce that. You can write in the end user license agreement. It's the most amazing, I'm serious, form of governance we ever came out with. It came out from software licensing, but you can actually decide how you want to run your game beyond IP with that document. You don't want to be that guy. You don't want to be the person that is writing down very harsh and unbalanced clauses, and probably you don't want to be the person enforcing them, even if they are. Video game industry is massive. It's really difficult to quantify and qualify the industry. You go from AAA publisher, global conglomerate, to a couple of people coding from their laptop. They're very different approaches to everything. But I'm positive. I've seen an evolution, a tendency to be much more user. I don't know what to call it, player friendly. At the end, the players are the center, and most of the developer and publisher are also players. So it's a community that is going for a better environment, to create a better environment.
Thank you.
There is a question there, and you go after.
Continue from.
No, sorry, I didn't see.
So I would like to use you as a presence, not so much with your expertise, which more than visible, but a little bit about your experience you had in relation with investors. Because my idea is that at the moment, first I will just mention that in late 1990s, this time the CEO of the such and such Europe, he told that the 21st century would be the century of ideas. And the point is at the moment that in the IP industry, that the moment is that is maybe inflation of ideas because it's too many good ideas. But still is the problem with the investors who still hold the position of the power with money. But just in the first break, I talked with Christina from SGA, And she told, when I mentioned that 1,200 euro is the fee and the lawyer fee for the patent application in Serbia, but it's not too much. But she answered, yes, but for a small studio, it's a big money. So my idea is, if you have experience that you was on the studios or gaming side in communication with investors, can you tell us some of this experience? Thank you.
An excellent question. So I will try and answer it to the best of my abilities. And you said that there is, and I really liked it, that there is an inflation of ideas in the 21st century. And it's basically, it is true, but it's, the answer to that is, it maybe sound trivial, but the video game industry, based on my observation, is that we reached the point that we already knew, for instance, for the movie and music industry. And for the movie and music industry in 20th century, so 30 to 40 years ago, they have already been reports and they have already been comments saying that each year there are more ideas for movies, for TV series and music than people engaged in the industry globally. So at that point, it was impossible for any of the studios, any of the publishing houses to even rationally think about creating, like making all of these ideas happen. And the same happened very rapidly with video game industry. There were already more ideas for decent to very good games, but there are parties being able to put money in creation of these games. And that's where the investors taken the advantage of being the picky parts. They can choose, they can pick, they can be very nosy, they can say, this game is good, but hey, we have seen several better games. But this is because the industry itself matured, and there are so many players and there is so much money in the industry laying on the table. That's why. And also because of the recent the February of this year, because almost everybody believed that we reached the end of the history, like globally, and nothing bad can happen globally to this globalized market. And we will just create more video games, create more technology, more consumers will buy, and then will buy, and the demand will rise constantly. More and more money will put in the market for creation of video games, but at the same time, developers and the investors became more advantageous, more picky with selection of the titles. I am not surprised with this. My colleagues from the industry, most of them are not surprised as well. And if I could comment on that, although you didn't ask, so for any of the developer that wishing to receive funding from the investor, it's basically to some extent the beauty contest. It's not necessarily about how good your game is at the end, because you don't know, you cannot predict the final outcome of the game. But you have to sell the idea, the promise that if this investor will put money in your project, they will earn money like twice or triple. This is how it works. It's like with any other, it's just selling stuff. It's as simple as that, regardless whether it's video games, movies, or anything else. Fortunately and unfortunately at the same time.
But also a basic point. I mean, you always need a good game and have done your own works in IP to make money and to have a return on investment. Now is a risk because there is a multiplication of title that is a good thing, but there are more video games that we can play. So the selection becomes more strict, even from the investment point of view. One of the things is, however, that things changing. Now there is also an evolution in investing in video games, because even investing in a video game that is not gonna do particularly well could be a sensible financial investment to be done because of a number of reasons. And because when you actually invest in a video games, you're not only investing in a particular title, you're investing in that studio. And that studio is not only that title, it is the connection, it's the network, is knowing those people, and their IP, even if it's not successful for that specific game, could be successful in other form, for another game, for another form of media. There are a lot of, failed video game projects that then became financially viable after that. It is a very active market, and it works a little bit differently, the classic financing of films, that with the bonds, with everything. There are so many different sources of financing, and people have been extremely creative. So this it's difficult to make a map.
Yes, my question is regarding the EULA. So what would you say, in your opinion, how much is it really an agreement that we should put some thought into it, and how much is it actually became just a template that people use pretty much with the same clauses and just agree with it? Like,
well, the template depends on the of course, if you're just starting your studios, your first game, obviously you're going to look around and look at the other end user license agreement and choose the wording that you like the most. But it's never a template, because it depends probably on the person drafting it. I don't know if I can make it so personal, but I mean, especially if you know the legal team of the company, you can actually, they're writing something like an author of a novel or an author of a poem. You can see the people behind the EULAs, and it depends on the game. It depends on the kind of market you want on the game.
Yes, my question was more, maybe I wasn't precise. So it was more like, how enforceable is it? Because we were talking about it, how some of the provisions from the EULA you don't really want to enforce. And then the question that comes up is, well, then why are we even, like, how much should we actually, how much is it just like a piece?
It depends on the country, on the case law, because these cases based on EULA, they're really, really rare. You will not have a single player that would actually challenge that in court. Also because the provider of the EULA doesn't want to go to court on that particular clause. Because one of the massive strengths of the EULA, and you will have to disagree with me in a second, is also the effects that it creates. So even if you write something in a particular way that is dubious enforceable, and you don't enforce it, it's just creating the people reading that EULA that is something that could be done. So this is a very dangerous chilling effect on the wind of the EULA. We do have, however, consumer association in particular countries that are really strong in fighting what is obviously an unfair contractual term under consumer protection. And even without cases, there's been in a decade a tuning down of the wording. For instance, we know some arbitration clauses are clearly void. We have Linden Lab that came in the US, Second Life 20 years ago. We have other aspects on choice of jurisdiction, of choice of law, that are obviously against consumer. But there are aspects of the EULA in which we know that some countries will never consider it a breach of consumer protection. For instance, total freedom of whatever it is within your game. Its internal game doesn't relate with the outside, doesn't involve payment. You can set up the rule of your game online however you wish, because it's beyond consumer protection. I mean, it's player versus player online will have a different wording than a kitty game. So it will depend, and there are limits. I want to say something positive. I mean, the drafting have become much more player friendly and much more enforceable without the need of these cases. that has been something rare. I mean, no other industry. Again, I'm not mentioning other industry, but no other industry actually changed the term and condition just because there is a backlash or a commentator pointed out that that was pretty mean without even giving legal grounds to say that was. It's been really proactive to make it a welcoming environment. There are exceptions, of course, but if I have to give a general comment, I mean, most of the EULAs that I look at the moment, the recent 2-3 years games, they're all pretty fair. Sometimes there are, especially in the general IP clauses, that could be better phrased to make it sound less inquisitive, less imposing. But or sometimes you notice that in the localization of the license, there is still mention of fair use. And this is something that personally disturbs me because no, we don't all have fair use. Some countries don't have fair use. If you leave it in the license, you are creating this global myth that if you listen for a song for just 5 seconds, it's not a copyright infringement, it's fair use. That is totally false. I hope they're not going to edit that sentence out. But there are a lot of myths that are wrong. And sometimes these vague wordings can help the expansion of this odd opinion.
But Christina, from the other angle, to answer your question, like with brutally honest legal answer is that as long as you operate within the boundaries allowed by law, by the consumer protection law and any other state-specific laws, that isn't enforceable. This is a legally binding agreement between you and your customer. And if that agreement is being broken by the customer, you can enforce it. You can go after that person if you want. I'm not talking about the PR backlash, etc. You can do it. You have legal means to do it. In some countries, you will first have to go through the consumer mediation arbitral tribunal, something like that. It's being introduced more and more often by the countries, but of course, you can do it. If you're not happy with the behavior of the particular customer, and the structure of the EULA that you proposed is legal, you can enforce it. Nothing stops you from doing that.
What happened? The EULA is written in one country and the customer is, for example, from the US. And then we have this, like, I'm asking this question because I was drafting our EULA for one video game before, like, in the past. And I realized that I drafted like a general draft and I sent it to our publisher, but I made a disclaimer saying, since you're going to publish the game in different territories, I believe that you should reevaluate this EULA concerning on which territory you're going to use it, because I don't think it should be just used generally everywhere, but it should be looked into by another legal professional from the territory that it is going to be enforced in. This is why I'm asking. I was just thinking like, how much effort I put into it, you know, but like at the end, the thing that you said, there are no cases. This is what actually was interesting to me. Are there cases? Like, do we have some practice?
You don't need cases for that. And the answer that the recommendation you received from the publisher was correct. However, it was not as detailed as it's supposed to be, because from one perspective, it's true that having one universal EULA for the entire world would not work. It will work only in the region that you are coming from if you draft it by yourself. So for instance, in Europe, it will not work in US in parts, it will not work in Asia in other parts. So the most practical approach, without being schizophrenic and trying to make EULA being compliant with over 400 countries in the world, which would not make any sense for any publisher or developer, is to structure the EULA region by region. So you have specific wording dedicated, and it's the way I approach that kind of projects for my customers is that I always pay attention to where my client is coming from. If the company is coming from European Union, the backbone, the very structure of EULA will be compliant with the European laws, because this is where the HQ is. If the shit hits the fan, it will happen probably in the European Union. At the same time, I consult with my colleagues in US. and I to introduce fragments of the EULA, which will be applicable only with respect to customers in the United States, and they will disregard the same section that was drafted for European users, and the same goes for any other region. So the four main regions are the Europe in general, not just European Union, Americas, Asia, and Australia. This is the most practical approach. Of course, you can go even further. It depends on the market that you target. If you know that your game will be published primarily in Japan, in Korea, in Asia generally, you should probably focus on that market first and then tailor the rest of the EULA for Europe and Americas. But if it's just like any other game, like for the general audience, you should probably stick to the European approach. And it makes it is also important to know that EULAs and terms and conditions in general, like any written communication with customers, will differ in structuring the wording itself if you do it in Europe and if you do it in US. The approach to saying the same things will differ. You will use different expressions. You will use different phrases, basically explaining the same legal mechanisms, not because it is legally required, but it's because the custom of the users is that they know what they're reading. So in particular regions.
If I can just follow up, we also became really obsessed with EULAs on everything, on audiobooks, on a lot of places where we don't actually need a EULA. And I think it mainly depends what you want to achieve with your player. Because at the end of the day, most of the things we write in the EULAs, they're already covered by general legislation. What we want to achieve, in my ignorant, what I think the thinking should be from the developer or publisher point of view, like we want to make it quicker and not go to deal with our players. So if they do something we don't like, we terminate the account or we give a suspension. That is the end game. For the rest, there is criminal law, there is data protection law, there is IP. So as far as this is what you want to achieve, you can actually keep it simple and as simple as possible. There is an old EULAs, I'm not going to mention the company, that more or less will say, don't mean we want. That was the entire experimental EULAs. They kind of make sense. This is what you want to achieve. So as much as, if the wording is clear, I think that if the wording is clear, what you want to achieve is under the sun. There is a lot of freedom of writing skill and creativity, and then it's even easier to localize if you're not very specific. Of course, the attempt is to reduce limitation, exception, and copyright, or prohibit what is normally an allow use within limitation exception. This is where it becomes a little bit more risky, because what you're doing, I mean, the extreme scenario, abuse of right. It could reach that level. I never saw that happening, but that is the theoretical end game. You could write something so extreme to become problematic. But so far, especially when it's there is a continuous relationship with the consumer base between EULAs, community guidelines, terms of services, you can suspend whoever you want if they're doing something you don't want. There is no need to spend too much time. But then lawyers, they do love writing them.
I will just add one last comment, and it's not about the EULAs themselves, because we sort of started this topic based on the user-generated content. We talked about it a bit, and we had some follow-up questions. But there is one particular instance which I will highly recommend to be very scrutinized with respect to how you approach that kind of EULAs. They are very, very important. And what I mean is the closed beta access to the game. This is the instance that it's extremely important that you sign the agreements with any of the users that will be participating in the beta, because what they report to you may influence the changes in the game. And that's extremely important, because it may happen that if you accept the changes that was proposed by user, you will not have rights to that change. And that may be problematic, but that's, if I would have to like name one instance, that would be that scenario.
And soon probably we're gonna to rewrite them all in order to make them age appropriate, depending on the kind of game you are. So it's gonna be a constant redrafting EULAs for at least another decade before we settle.
That's all clear when you think about the transaction between a video game producer, video game developers, or the person who sells video games directly to the gamers, to their clients. But what happens when you use a third-party digital marketplace, when they are incorporated in the US, for example, and they have their own understanding of the IP law, and they don't care necessarily about what the EU law states or anybody else. So, for example, Steam.
Yep. But from perspective of developer, publisher, or user,
All three.
it differs. So from the perspective of developer or publisher, it doesn't matter if they're in US, because in the B2B relation, business to business relation, consumer protection laws do not apply in this situation. So you, as a company from Belgrade, Serbia, you have every right to enter into a contract with Steam and in US, and that agreement will be governed by the US laws. Simple as that. You agree to be obeyed by the laws of the US because it's B2B relation. From the perspective of user, everything I said before applies. So regardless of the hypothetical EULA that would be used by Steam and imposing on you certain obligations which are forbidden in Serbia, they will not apply. So what they did, if you look at the EULA from the perspective of user, you will see different sections for different regions in the world in Steam already. And you will find a section that will apply to you and different section that will apply to American users.
That's the point. Is the process of drafting one's own EULA less important when using third-party marketplaces like this?
Oh, okay. And that's so. If you put your game on Steam, you don't need any EULA. If you don't upload any of your own EULA, the template of the EULA provided by Steam will be applicable.
That's two questions online as well. So if I can kindly ask for technical just to show the screen for Anastasia, who would show the questions which were given online. And then to see if Anastasia, you're there.
Yes, hello. I know you have missed me. So I have a few questions from our online participants, and they're very different, but let's get to it. So let me share my screen so that you can see. So one is, we're going back to trademarks with the first one. So the question is, to just read it out a little bit, is if a new trademark owner asks me to move or change a word which has become the new trademark owner's trademark from my app on online stores, I can do that in the app name and the app description, but how would I proceed with the URL? Because moving any part of the URL would not change the app, but the app would disappear from stores and make it unavailable online.
It's more technical question than legal, and it basically stems down to what the new trademark owner will agree to. Most of the trademark owners will agree, and they will be satisfied with just changing the name, the word in the name description, the app description, everywhere the title is being showed up. And they will say that, okay, you can leave the URL because I know it's too much of a trouble for you. At the same time, they can enforce you to also change the URL because they will say and they will claim that it is still using of my trademark. So this is the moment when you should negotiate with that third party, try to explain how much damage that will cause to your own company and your game, and that you didn't know, and that you're very sorry for that. But basically, the trademark owner in this case is always on the higher ground.
that is the mistake of the studio, because they didn't search the database. It's true.
Well, one answer would be to say yes, that it's their mistake, but at the same time, being an independent studio, creating your first game and being able to search throughout the databases throughout the world, it's some sort of an impossible task to do, unless that studio also know that there are special commercialized databases allowing them to use very scripted ways of searching for the name. They would have to go database by database, WIPO database, US database, Canadian database, UK database, and manually try to find whether there is a word that was trademark, that was registered as a trademark somewhere in the world. For a non-lawyer and also for non-IP lawyer that has never used any of the commercial databases available, which you have to pay to be able to use them, I would say it's almost impossible thing to do. So I would not say that's a mistake of the company.
No, but plus could be a genuine mistake. I mean, you do the searches and you don't do them properly, you don't find them, and sometimes even if there is the approach, no, I cannot imagine that word being trademarked. It's such common use. It's used. There are another 50 video games with the same name on the Apple Store. Because of this evidence, you think that there is no risk, but then when the trademark owner send you a letter, you have to choose, or you negotiate, or you try to challenge it in court, and then trying to prove that the user is not confusing, or that that trademark is weak or has not been used, and fight it in court might probably be more expensive than just changing the name. So you have to be strategic. That's why we tend sometimes to give opposite views, because this is the law, these are the limitation exceptions, these are the case law, but in practice, there could be a much easier position. And when you have a register right, you are in the weaker position on the other side.
What I would recommend is for any of that person to go to Gaetano, because they have a clinic at Queen Mary, and perhaps there will be some willing students to do some digging and try to find a name.
Yeah, but that's going to take a decade. Yes.
I think you are waiting for the second question. Sorry, I did not hear it, but I just assume. So the second question refers to the increasingly developing market in video games in Africa, as well as how this would be handled in different regions. So according to our participants, a minimum of 4 million players use credit cards in order to pay for games on Steam every month in the continent of Africa. And what would what would be the approach for IP protection in different regions in this case? I guess it refers more to Steam-based releases.
And do you see any specific differences in IP?
No, but I haven't. But then again,
now, if this question was about music streaming, I knew the answer immediately. Just,
no, I was about to say that regretfully, again, coming from the more of the practical side of doing providing legal services in video games, I have very, very rarely encountered any situations, any issues concerning Africa as a whole. So based on that, my knowledge with respect to this region is also fairly limited. However, what I know, and this is not an answer to this particular question, but this is some sort of a problem that is being emerging. And it's when I saw the question, I have immediately thought about it, because not that long ago, I had a very long discussion about it. Let's say there are 4 million using credit cards in Africa using Steam. Unfortunately, a very high percentage of these 4 million players is being money laundering. So the credit cards that are being used in Africa were not actually used by the users which play games in Africa, but they are used for the money laundering purposes. So it's not IP, of course, related matter, but just as a food for thought.
On the IP side, one of the difference, for instance, South Africa is one of the very few countries that has a sui generis protection for software. So we don't know how this will fit, but I assume easily, because of course it would be licensed anyway, and the extra right that they get in South Africa wouldn't impact on the rest of the global distribution. There are probably since there are 3 countries that are actually the first one, the one that are fast forwarding production and creation of video games. I will assume that whenever there is going to be a clear, regional custom in publishing and distribution of video games, these 4 countries will have the stronger voice in setting up the custom based on the same IP system. And the other thing to remember, the regions, I think they create difference when it comes to marketing and when it comes to taste in video games. But on the IP strategy, there is a single way to look at IP and commercialize it.
Any other questions from the on-site attendees? Of course.
Thank you, Gaetano. So, okay, I'll be very quick with, obviously, whenever we accept a EULA, I'm coming back to EULA, so sorry. This consent is supposed to be stored somewhere, and I recently got in touch with Steam, and they couldn't really tell me on the first shot where it's stored, and I eventually discovered. And what I got a little what I found funny is that this consent can be easily erased, and therefore you can accept EULA or decline EULA as much as you want. So where is the actual consent in accepting a EULA? And since it's an enforceable legal document, technically you can really pursue someone for breaching the EULA. How can someone actually, is there any evidence that someone actually accepted the EULA, since Steam, for example, Steam does not store this information online?
Well, I can't speak for Steam, but what you're saying is interesting to the point that if there is any platform or any publisher that has its own launcher, which forces you to accept EULA before you can start playing the video game, and if you accept that EULA and the entity that requested you to do so didn't store your answer, well, you snooze, you lose. And I'm saying that to the platform, yeah? So they cannot enforce you with respect to the document that they cannot prove yet that you agreed to. So it's like with any other document. This is what I mentioned during my short speech before, that if you don't have document, it can be digital document. Well, there is no proof. They can, of course, say that our system would disallow you to go through and start playing the game without accepting the EULA. But you may also argue that, but I haven't seen any EULA, so maybe there was a glitch. Of course, so in that relation, I would say that the odds will be in favor of user, not the entity.
I didn't know that they didn't store it. I mean, I always assumed that someone had a copy somewhere.
It's stored locally. Never on their servers, at least they don't state that they actually store it.
I didn't know.